I've just put it on, Patrick. Okay, good afternoon, folks. Good evening, even. Okay, that's better. Good evening, you're all very welcome. And some of you are ACJ. Sorry about the pillar in the middle. Anybody who wants to move on up, please do, because there's plenty of seats. So I'm going to start off like a comedian, because a funny thing happened on the way here today. I found myself out at a conference in Maynooth University, Women in the Law, and stayed a little bit later than I should, because Minister Lynch Kathleen Lynch got delayed en route, to discover that my car was clamped for the first time in my life. So if any member of the Garda Síochána are here, and I broke some traffic laws on the way in, now you know it. And I'm 80 quid lighter, but you're worth it, right? Okay, so for those of you who are not ACJRD members, because there are a few of you here, I'm just going to very briefly remind us that this organisation was set up some 15 years ago, and we have the privilege of having some founder members here tonight. One whom we know has been our patron, Judge Michael Moriarty, but recently I ran into another founding member, an old friend, who's now sitting with us today, and that's Judge Gillian Hussey, and you're very welcome back to the fold, and we're going to hang on to you now, you don't get in the way. Okay, so it's important that I point out that this organisation is about a cooperation and work between a lot of people. We have a very hard-working volunteer board, two of whom recently retired, one of whom is here tonight, and that's Kieran O'Dwyer, who represented the prison service on the council, and we're taking the opportunity to thank you, Kieran, for all that good work, and delighted that you're remaining a member. It's like I said, nobody gets away, do they? And Brendan Callaghan from Justice was also recently retired. And they've been replaced, respectively, by Jim Mitchell, who's here with us, and Donncha O'Sullivan from Justice, and both of you are very welcome to join joining the council. My colleague and Vice Chairperson Finbar O'Leary is sitting over there on the extreme of that table. Jane Farrell is from the DPP's office, and she acts as our company secretary. Nora Gibbons from Barnardo's, Kathleen O'Toole, about to be replaced from the Guard Inspectorate. Geraldine Hurley from the Court Service, without whose good offices we wouldn't have had this building this evening. Dre McNally from Probation Service, Eugene Corcoran, the Garda Síochána, and Dr. Shane Kilcummins, University College Cork. So that's who we are in terms of the board structure. But really the work gets done at the office by Danielle Hannon, who's our manager, and Geraldine Corcoran, clerical assistant, whom you would have met as you registered, and ably assisted by an array of interns. We've got Patrick here, we've got Seamus and Perez, we've got other people who have helped us over the years, who keep coming back as well, so that's fantastic. So today is one in a long line of ACJRD annual conferences, with the most recent ones being Women in the Criminal Justice, Perspectives on Sex Offending, Minorities, Crime and Justice, Community Custody, Aftercare, etc., going all the way back to 1999. And what we like to do then is actually to compile those papers, because everybody doesn't get a chance to go to every single workshop, because the way that we organise it is that we have some plenary speakers, then we have workshop sessions on the back of those plenaries, followed by more plenaries and more workshops. So it's a very, very busy day when we have our conference day. We used to, back in the good old days when people had more money, have a 2-day conference, but that doesn't happen anymore. So we just cram as much as we can into the one day, and folk barely get an opportunity to point their soup and sandwiches before they have to go back in. So this year's conference, Mental Health and the Criminal Justice System, fell during World Health Week, which was actually a coincidence, but it really felt very good on the day. The germ of the idea of actually doing something in relation to mental health and criminal justice occurred in one of our working groups, in the mental health working group that our Vice Chairperson Finbar O'Leary chairs. And we had meetings with the previous minister in relation to mental health. Mr. O'Mahony, no, what was his name? Maloney, Minister Maloney. It's terrible the way people forget. In politics, 5 minutes and that's it. You're remembering. Terrible. Anyway, so we had those conversations back in the day, and a very vibrant working group, and their work encouraged the council to actually select this topic. I'm terribly pleased, and one of our plenary speakers will be more familiar with this, and Jimmy Martin here in the audience than the rest of us, but we're now in a situation policy-wise where there's going to be an interdepartmental review group looking at mental health in the criminal justice system. So I'm very pleased that these conference papers being launched today are going to be on point, and we've had discussions in the council to the effect that we'd like to put in a submission on behalf of ACJRD using the platform of the conference papers for that purpose. So the diversity attained during the conference was demonstrated in the range of the 6 plenary speakers to 6 workshops, and in line with previous ACJRD conferences, there was interdisciplinary discourse facilitated through contributions from policymakers, agencies, professional and voluntary practitioners, and those who suffer from mental health difficulties from many disciplines, from home and abroad, some of whom made it here today for the launch. And methodologies discussed included the therapies that are in vogue, early intervention, survival and growth. And they were presented from both a practitioner and a recipient perspective. And that's a model that we followed over the last couple of years. We're trying to bring people together who might not ordinarily meet, and which almost mirrors what our organisation is about, that we try to be as cross-sectoral as possible between practitioners, policymakers and those people on the ground. The conference could not have occurred without the altruistic generosity of plenary and workshop presenters who share their expertise and experiences, which you will agree on reading the conference publication will serve to create new insights in that space where mental health meets criminal justice. Now, I'm not going to, you have the copy of the papers, you see the high calibre of speakers that we had on the day, so I'm not going to go into a lot of detail. A lot of them are very well known to you, and the plenary speakers included the Secretary General of Justice, who was there on behalf of his minister, and Jimmy Martin and Barbara Nick Angus did the presentation in relation to what government are doing when they meet in that interdepartmental space. Professor Harry Kennedy, Deborah Aldred, Dara Robinson Solicitor, Fergal Black and Dr. Andrew Fraser were the other plenary speakers, which meant that we actually had influences from both the UK and from Scotland at plenary level. But that also transposed itself into the workshop spaces where we heard both morning and afternoon, we heard in relation to juveniles and mental health, which we discovered in our research coming up to the conference was an area that actually needs an awful lot of exposure from both a research perspective and otherwise. And the other workshops included Eve McDougall, who was a Scottish lady who offended at age 15, was arrested for stealing bread to feed the family, and talked about how that impacted her and how she uses art in her recovery. Conor O'Neill talked about the really important work that he's doing from the point of view of prison inreach and course liaison. The GROW organisation sent 3 representatives, and a very brave person called Paddy, who actually was in prison and recovering from his particular difficulties. So there's a huge variety of perspectives, and I think the strength of the papers will be that it actually brings all those perspectives together in a way that hopefully will inspire us all to look at this area where the two disciplines meet and try and find solutions for people who are possibly better served by being taken care of than by being punished. I'm going to briefly ask our patron, Judge Moriarty, to formally launch this evening's papers. So if you can give please a warm welcome to Judge Martin Moriarty.
I thought I was getting away with a non-speaking role, but Maura manages to extract a bit of toil and labour from all of us, and I think that's probably why the association has fared so well. Going from a less than scrupulous study of every word of the papers, I do recall what a success it was. I think it was the most successful conference that we have hosted in the 15 years or so of the association, and I think the input from the various speakers coming from all the different disciplines and coming from different jurisdictions led to a real kind of dynamic. And from having initially set up this association as a talking shop to some extent, because people weren't really talking to each other in the different constituencies in criminal justice, it is perhaps a measure of how far, without any sort of arrogance, we have come, in no small way due to Maura's committed leadership, that we now are having a genuine input into policy, and that the deliberations that are taking place between the different groups that we represent are going to be not a mere talking shop, but are something that may actively and should affect policy in the future. So I'm very happy to propose the adoption of our report on what I think was one of the most significant conferences we've had to date. And that I will regard as having earned my brief fee.
Thank you very much. Thank you very much.
Okay, so now we move on to the second reason why we're here this evening. Ordinarily, we have two separate events. So this is a bumper evening for ACJRD. Normally we have the conference launch in February of each year, and then come May we tend to have the annual Martin Tansey Memorial. It may be slightly crass to say this, but that never stopped me before. But the reason, one of the reasons that we're actually doing this is really because of huge cut in resources over the recent past, and very astute management of what resources we have by our manager. We're hopeful that any slowdown that we've currently had in relation to our research outputs and our workshop groups, that we would love to have more active. We're hoping that we will be able to find the resources to actually to yield more and give greater output. We know that we don't charge a heck of a lot of membership every year. That's, however, very, very important to us, and please, we'd be asking you to help us increase our membership, because we do believe that what we're doing is a valuable contribution to criminological discourse. Okay, so anyway, that's the sales pitch over. But it's really I suppose sometimes scary in the NGO world these days, when you have the kind of volunteerism that we're blessed with, and the kind of our manager and our clerical assistant are both part-time. But it's sometimes a little bit scary when we think actually this could all go for the want of a few bob. So if anybody has any ideas as to how we can meet those challenges, we're more than willing to actually take help and advice, etc. in that regard. Now, I'm wary of Martin Tansey overlooking my shoulder when I should be doing more dignified presentation, so I'm now going to get dignified. Okay. So, for those who don't know, Martin Tansey was one of the founding members of this particular organisation, with others, as we mentioned earlier on. He was very inspiring. It was him that challenged me to get involved with the organisation, and unfortunately he passed on after quite a long illness some short few years ago. And we felt that a respectful way to remember him and all of his work would be to have a lecture every year in or about the time of his death, which was in March, for the purpose of remembering him and remembering the work that was so important to him. our first lecture was in 2009, with probation, rehabilitation and reparation, followed in 2010 by therapeutic jurisprudence in theory and practice, and followed again in 2011, last year, where is our criminal justice system going? The title, as you know, of today's annual Martin Tansey Memorial Lecture is Prison Policy in Ireland, Rehabilitation, Research and Reform. And this sits very well with Martin's beliefs, which included the rehabilitation of offenders. He was regarded by some as the founding father of Irish community sanctions, and he always wanted to advance the independent criminal justice research space. He did work also with long-term prisoners for quite a long time, and he was a very respected member of the parole board. So today's Martin Tansey Memorial speaker has chosen very well, and has chosen in a way that would actually honour Martin's memory in a very, very real way. She is Dr. Mary Rogan, and she is a lecturer in socio-legal studies at Dublin Institute of Technology, where she teaches law, criminology and prison policy, as well as facilitating a number of community-based learning projects. She is also a barrister. She has as many qualifications as you could count on one arm, actually. Mary is the author of Prison Policy in Ireland, Politics, Penal Welfarism and Political Imprisonment, which was a book that was published just a year ago this week by Routledge. She is also chairperson of a sister organisation that you're all aware of, the Irish Penal Reform Trust, who do a huge amount of work in this area. It was with great pleasure that I now invite Dr. Mary Rogan to give the 5th annual Martin Tansey Memorial Lecture.
Thank you very much, Maura. Very good evening to you all. I didn't have the pleasure of knowing Martin Tansey, but the principles that he stood for and sought to realise mark him out as a visionary and an innovator. Those principles continue to be relevant and require our energies and ideas to see them realised today. I'm very pleased and humbled to have been asked to deliver this, the 5th lecture in his memory, and I'd like to thank Maura Butler and all at ACJRD for the very kind invitation to speak, and my thanks also go to Danielle Hannon for her assistance in preparing for this evening. And we were just reminiscing, my first encounter with ACJRD was back in 2003 or 2004, I'm not exactly sure, but I was very delighted to receive a generous bursary to attend their conference in Kilkenny that year. So I hope to go some way to repaying that compliment this evening. I also should thank the IT specialist who helped me with this rather unusual presentation which I'm about to deliver. It's an experiment which I see is already going moderately wrong on the screen. It's the first time I've used this particular software called Prezi, so I apologise if you start to feel dizzy during it. It jumps around quite a bit, but we'll try it anyway. They're my contact details if you want to complain about it afterwards. When I read about Martin Tansey, I thought there were 3 themes I might draw on which had particular relevance to his legacy and ideas, and I'm really delighted that Maura picked up on that. The first was the concept of rehabilitation, the second, the possible impact of research and policy, and finally the role and importance and potential role of interest groups within the criminal justice system. So I propose to examine those three themes within this lecture. First, I'd like to track the concept of rehabilitation within official thinking since the foundation of the state. I would explore when and how this term first came to be used and how it has fared since. Second, I'd like to examine the barriers to and the role of research in the making of prison policy, and to say a few words about the data deficiencies in our system at present. Finally, I'd like to look at the role of interest groups within the criminal justice system, and specifically their effect or potential effect on the formation of prison policy. So looking at the concept of rehabilitation, first of all, I had the pleasure of hearing Professor Fergus McNeill give this lecture in 2009, and he gave a masterful examination of the concept of rehabilitation, which I would not be able to emulate, nor indeed would I wish to rehash. My focus this evening is on how this concept emerged, was fashioned and developed in Ireland. I'm aware that I'm using the term concept of rehabilitation, as I will also have one or two things to say about how rehabilitation as a practice worked out in Ireland also. As Ferguson McNeill said in his lecture, rehabilitation is both a penal concept and a penal practice. The word is also used to describe a process of being rehabilitated or an outcome. As Fergus made clear, there are very many other very vexed questions arising out of any attempt to describe what rehabilitation means. Some see it as a quasi-religious notion, others a form of re-education, others a kind of medical treatment, some a paternalistic, coerced and enforced set of practices, still others something which is legitimate only when engaged in freely by an individual, him or herself. In this talk, I'm not interested in what rehabilitation is, might be or should be, so much as how the concept itself has developed in Irish penal thinking. My emphasis will be on the term, or more specifically the idea of rehabilitation, was conceived of and used by policymakers. The way in which the concept has translated into practice is, of course, an entirely different matter. What I want to explore is how Ireland's penal policymakers used the term and what they meant or what they thought they meant when talking about rehabilitation. How policymakers use terms like rehabilitation is revealing of the sensibilities of those policymakers regarding punishment, the objectives of punishment, and the relative importance or priority between competing objectives. It is therefore a useful shorthand by which we can understand penal thinking generally. In prison policy in Ireland, I attempted to look closely at what policymakers were doing, or again thought they were doing, at various key points in the history of our prison policy, believing this to be an essential and somewhat underused way of understanding penal change. There is a growing literature on trying to understand the actions of policymakers and the policy process as a way of explaining penal change. But in this regard, I wish to draw most particularly on the work of Loader and Sparks, who suggest that it is important for us to understand how policy actors themselves talk about and conceive of their actions and intentions. Advocating a process they call historical recovery, Loader and Sparks state the following: the procedure we envisage would subject events to more searching forms of historical research and reflection, aim to explore their interplay with extant political imperatives and programmes, and seek to explore the ideas and meanings that actors mobilise to encode or decode events and name the legitimate response. Now, essentially, the fun part of this is we get to revisit and examine historical and contemporary politics and see how politicians and civil servants use language. So looking at rehabilitation as a concept in Irish penal thinking, I think Ireland provides a particularly interesting place to study the concept of rehabilitation and how it has been used by policymakers. Our shared penal, legislative and administrative history with the United Kingdom meant that at independence we had many of the structures in place which were associated with the rehabilitative turn in penal history. The Prevention of Crime Act 1908, the Children Act 1908 and the Probation of Offenders Act 1907 were all British inventions. We also had a penal system which was, as Niall Osborough states, largely the product of English penological thought, with prisons, particularly Mountjoy, exemplars of Victorian thinking on how to organise punishment. While we had these foundational structures in place, Ireland took something of a different path in comparison with its nearest neighbour with regard to both prison policy and rehabilitation after independence. This makes Ireland a very interesting case study in which to study the conditions in which rehabilitation can be propagated. Now, when we're talking about rehabilitation, we are also, of course, talking about penal welfarism as an approach to or period of penal policy associated most particularly with the years 1895 to the 1960s. Penal welfarism, also known as or considered to encompass correctionalism or penal modernism, as a penal idea has been subject to innovative and expert analysis by David Garland in what I consider to be his best book, except perhaps his most recent one on capital punishment, Punishment and Welfare, which was published in 1985. And as an aside, I think it's very interesting to reflect on why that book has not spawned nearly so much in the way of penological scholarship and critique as his very influential Culture of Control did when it was published in 2001. Now, when we talk about penal welfarism, this wider concept, in which rehabilitation is embedded. We are talking about a period in penal policy and penal thinking which had certain key or characteristic features. These include particular penal practices, such as attempts to divert people from prison through the use of fines and probation, and generally a far greater number of sanctions which required the input of a number of experts drawn from the social and psychological sciences. There was also a distinct transferal of responsibility for dealing with those who had committed crimes from private charity to a state-funded and administered system. Now, the prison within this took on a new role and position, being decentered within the penal welfare complex. Many of the new sanctions introduced during this period were conceived of as alternatives to imprisonment, while others functioned to remove certain classes of offender from the prison setting entirely. The prison also became a place, in the imagination at least, of transformation of individuals, a setting for treatment rather than simply punishment. The representation of those convicted of crimes and of punishment also changed. A new language of reform, correction, normalisation betrayed the movement which sought to support the inadequate, as they were termed, de-emphasised personal responsibility to cure and to restore. Tim Newburn and Radzinowicz and Hood also described the period as one in which there was an increased sense of scepticism about the efficacy of prison and an increasing optimism about alternatives, as well as a desire to utilise the principles of social work when dealing with those convicted of crimes. Now, scholars such as Lucia Zedner and Nick Ryan have cautioned against indulging in a kind of penal nostalgia about these years, noting that repressive elements existed within the prison system during that period as well, and conditions within prisons continued to be difficult. And that's a very important warning to bear in mind. However, it has come to be accepted that this period of penal welfarism gave way in the 1970s to a penal era which emphasised punishment rather than welfarism, austerity in prison conditions, and a greater use of prison. That, at least, is the narrative from the USA and the UK. And in this part of the paper, and this is the reason why I'm using this unusual format, because it's got an exciting timeline function, I want to explore the development of the concept of rehabilitation in Ireland. So what of Ireland? Well, as I have mentioned, we had the legislation characteristic of penal welfarism at the foundation of the state. We also had a series of institutions outside of the prison which had as their aim the transformation of behaviour as well as control. These included the inebriate reformatories while they lasted, and the extensive use of institutions now infamous such as the Magdalen laundries and the mother and baby homes, as well as the industrial and reformatory school system. As Shane Kilcommons and others state, the kind of penal welfarism that existed in Ireland did so through a variety of sites outside of the prison. Post-independence, these institutions remained very much in existence. However, in the context of prison policy, the notion of rehabilitation was largely absent in the language and thinking of prison policy makers. More basically, there is little evidence that those policy makers thought deeply about what the prison was for at all, or what its objectives might be. The fact that there was not a great deal of consideration of rehabilitation as an aim of the penal system is therefore hardly surprising. Prison policy makers were far more occupied about cutting the costs of the prison system and actively avoiding innovation. As I have described in much greater detail elsewhere, ministers and departmental officials were excessively cautious and conservative in these years, resulting in a period of stasis in prison policy in the post-independence period. However, on the few occasions when public officials did describe their thinking about the role of punishment, the rhetoric employed was that of progress. The form of language used, however, was dressed in religious or moralistic tones of reform and salvation, reminiscent of Victorian ideals of penalty surrounding saving, the regenerative power of work, and moral reform. And this was shared across party lines in the 1920s. The Cumann Gael Minister for Justice, Minister Fitzgerald Kenny, stated in 1928 that in dealing with prisoners, the main object is to endeavour to reform them, to endeavour to bring home to them that though a man may have fallen, he can rise again. Our idea is to try to save these prisoners. Rehabilitation as such was not a word familiar to the penal policymakers of this period. The idea of changing prisoners or helping prisoners to change themselves was more closely related to the Christian idea of saving rather than any broader or indeed more secular notion of rehabilitation. That said, the fact that, though they were undoubtedly paternalistic, it is significant that the policymakers of that period were not using a punitive language. Things were a little different in the 1930s and the 1940s, with the language of rehabilitation essentially absent from official penal discourse. In 1947, however, the Irish Labour Party carried out an examination of Portlaoise prison arising out of disquiet concerning the death on hunger and thirst strike there of an IRA prisoner, Sean McCaughey, and that's taken from a mural depicting him. There was a great deal of public concern about the conditions in that prison, which translated into more generalised critique of the prison system. The Labour Party's report, which ended up actually being the first policy adopted by any Irish party on the prison system, called for the establishment, again the language is significant, of colonies rather than jails, which would allow for the segregation of prisoners and which would provide work and training. Significantly, they planned for longer-term prisoners to be accommodated under the care of a doctor and a psychiatrist, and for such prisoners to be equipped for release through physical and through moral training. As for the government of the day, however, it implemented the prison rules of 1947, which, as many of you will know, were again largely Victorian in their outlook. Those rules, designed to govern every aspect of prison life, were essentially administrative, with an obvious concern for hygiene, cleanliness and good order. Within those rules, there was little attention devoted to the much broader question of the treatment of prisoners in a rehabilitative or penal welfarist sense. The language of rehabilitation was, however, beginning to appear during this period. For example, the visiting committee of the prison at Sligo, which still existed, commended the changes brought about in prison regimes in the 1940s for their impact on the rehabilitation and reformation of the prisoner. These, however, were isolated pockets, and rehabilitation did not penetrate official thinking for some time to come. There were some signs of change in 1958 when the then Minister for Justice, Oscar Traynor, argued that rehabilitation was not possible in Ireland because sentences were too short. However, change was on the horizon, and in a couple of years, rehabilitation went from being something which was unusual, a bit exotic and rarely spoken of, to a central idea behind penal thinking, something to be proud of and something to show off. And this happened during the crucial decade of the 1960s. Rehabilitation became fashionable in the Ireland of the 1960s. Temporary release was introduced in the Criminal Justice Act of 1960. It was introduced not to alleviate overcrowding, which was part of the reason for its later introduction in the UK, and indeed the use to which it was put in Ireland later, but as a humanitarian measure for prisoners who needed to be at home for whatever reason, and to prepare those prisoners for release. This was an indication of things to come. In 1962, Charles Haughey became Minister for Justice, and I've written elsewhere about the impact he had on the Department of Justice, which was, in my view, significant and long-lasting. No doubt this was a young minister in his first portfolio, desiring to impress and to be seen as active and forward-thinking. And his language is hugely significant, and he is especially comfortable with the concept of rehabilitation. He said, "Once I'm convinced that new methods or intensification of old methods or changes of direction would lead towards an appreciable diminution of crime or greater rehabilitation of offenders, I will not hesitate to take the necessary steps." Haughey used the term rehabilitation repeatedly in his discussions about prison. And here's another quote from him from 1962, where he said, "Prison will always be a place of punishment, but it seems to me that our prisons nowadays must to an increasing extent become places of rehabilitation as well. Insofar as rehabilitation may save a person from the misery and degradation associated with a life of crime, it is entirely justifiable on humanitarian grounds alone. In addition, however, it can be regarded as something which brings a positive benefit to the community as a whole. It can mean the difference between a former prisoner continuing as a burden on the community or becoming a useful member of society. And he had the following to say about temporary release. I am very enthusiastic about the system. The idea that you would trust somebody to go out into the world to enable them to readjust themselves, these are the important things. And he argued that its use was enormously beneficial as it showed to a person that we trust him, and it proves that everybody isn't against him. And overall, he considered temporary release could have really satisfactory results. And the contrast, I suppose, with even what's being reported in the papers today probably couldn't be more clear. But it was not, however, solely Haughey who was experiencing these new impulses and feelings, these winds of change. The Department of Justice was also working on proposals which can be described as having a rehabilitative ethos. Haughey and Peter Berry, his Secretary General in the Department of Justice, combined their forces to establish an interdepartmental committee on juvenile delinquency, the probation system, the institutional treatment of offenders and their aftercare. Again, that language was revolutionary in the context of the time. And Haughey himself remarked that the recommendations made by the committee had, in the main, as their aim, the social rehabilitation of the offender. And I just want to draw your attention to the week that's in it, to what Charles Haughey said about St. Patrick's Institution in an interview on RTE television in 1962. He informed the interviewer that we have a great deal of plans and ideas in mind, including the primary hope to obtain a new, more spacious building, the provision of an educational psychologist and a matron to provide a feminising influence on the boys. And he also had plans for teachers with degrees in psychology to provide education for those in St. Patrick's. That was 1962, so we don't move all that quickly in prison policy. The Interdepartmental Committee, established in the 60s, engaged in activities which were also characteristic of penal welfarism, that is, research. There were undoubtedly somewhat amateurish attempts to establish the case histories of people detained in Mountjoy. And while this was undoubtedly modest, this desire to come to know the offender, to pathologise, to diagnose, to cast a criminological gaze on a person is certainly characteristic of penal welfarism. Significantly, this committee also sought out and apparently read Penal Practice in a Changing Society, Aspects of Future Development, a UK Home Office publication from 1959. And that publication is considered to represent some of the most developed forms of penal welfarist philosophy and practice. And the committee also got results, which again something is perhaps rather rare in the history of Irish prison policy. And again, its proposals are characteristic of penal welfarism. It is possible to attribute the development of a psychiatric ward in Mountjoy, the reopening of the school in Mountjoy, and the expansion of prison trades, along with the introduction of the corrective training unit, to the work of that committee. But the Department of Justice had even more radical plans for prison policy in the 1960s. In the early 60s, a number of proposals which never made it into the realm of public discussion were certainly penal welfarist in nature and self-consciously and unashamedly aimed at rehabilitation. This thinking was going on within the department. The department was, for example, considering whether to use abandoned farms in the west of Ireland to provide temporary or permanent housing for groups of prisoners or prisoners together with their families. And it was felt that the prisoners should be paid for their work on their farms with a contribution to come from the state. And no objection was envisaged as likely to arise in respect of that scheme. An official in the department was also writing this revolutionary stuff. Prison should mean two quite different things: a means of rebuilding and restoring the failure, and a punishment severe enough to be an effective deterrent. And apparently that person held on to their job. The media reports of the time were also using this new language, this exciting, fresh new language. The Irish Independent, for example, carried a very favourable report saying the developments represented one of the most encouraging steps forward in prison reform and rehabilitation ever taken in this country. The Irish Press in 1967 contained a feature piece called Our Prisons Today, arguing that the emphasis has now passed from punishing men to attempting to cure them of the disease of crime. That same year, the Evening Herald reported that a wind of change is blowing down our prison corridors, thanks to the introduction of corrective training, work parole, and changes in the work practices of prison officers. One very significant example of increasing media interest in penal affairs came in the form of a television documentary made for Tansey as part of the Discovery series in 1965. And this was sanctioned by the then Minister for Justice, Brian Lenihan Sr., who hoped that such a documentary showing the new methods of treatment introduced under our penal reform programme would lead to greater public interest and cooperation in the efforts of prison administration to secure the social rehabilitation of those discharged from prison. And this programme apparently had, again I quote, the Minister's enthusiastic approval, and it was even hoped to show it at the then forthcoming United Nations Congress on Crime Prevention and Treatment of Offenders in Stockholm. And the discourse of the documentary was characteristic of the period. The voice-over attested, one of the constant factors in crime is the lack of education and alcohol. A welfare officer was filmed saying, "Now don't forget, my job as welfare officer is to help you and your family." Thanks, Jim. The governor was also shown guiding prisoners into what was described as useful therapy. An interview with a warder elicited this response: "The old-style warder was custodian. Today's warder needs to be half psychologist, half schoolmaster, and as much the prisoner's friend as his guardian." And the documentary concluded that with a prisoner there is no point being tough. The greatest truth of the prison service is that tough prisons are always full. Let us have prisons that can one day lie empty. Such was the perception of change within the system that the documentary asked, "Have we simply gone soft on men?" To which the governor interviewed replied, "We are not here to punish men. Our intention is for them to leave here as better citizens." The Department of Justice was particularly receptive and enthused by this project, reflecting an openness towards penal matters that dissipated in the following decade. Some of this openness must also be attributed to the extremely favourable portrayal of the Irish system and the approach of the prison authorities given by the filmmakers. The producer of Discovery wrote in the RTE Guide that Ireland had the most enlightened penal system in the world, and having been in many prisons before, he had never encountered such a reformatory atmosphere as he had done in Mountjoy. The fact that this kind of language and assessment was that approved by the department is itself striking. During this period, justice officials were more than comfortable with the notions of rehabilitation, assistance, training, humane conditions, etc. At no stage was there a discussion that there might be a public outcry about the portrayal of the prison system in such a way, or concerns that either voters or politicians would not bear the evidence contained in the documentary. The department, by contrast, wanted to put forward this position in the media, suggesting that it was, at this time at least, most enthusiastic about the ideas of modernisation of the prison system and prisoner welfare. Ultimately, the ongoing commitment within the Department of Justice to this change language led to changes in legislation under another young minister, Dessie O'Malley, who became Minister for Justice in 1970 at the age of 31. He piloted the Prisons Act of 1970 through the Dáil, though it was essentially a civil service-driven development. The Prisons Act 1970 was the legislative zenith of this period in Irish prison policy. Its immediate impetus was to provide statutory regulation for Shanganagh Castle, which had been opened in 1968 to provide a semi-open institution for young people. However, the Act went further. Its preamble and explanatory memoranda stated that its purpose was to enable the Minister for Justice, for the purpose of promoting the rehabilitation of offenders, to provide places other than prisons for the detention of persons. Rehabilitation was now an official aim of Irish prison policy in the Irish prison system, and it was contained in legislative form. Interestingly, this has never been repealed. Moreover, the softer term place of detention was introduced into the Irish penal lexicon. In the Dáil, the Minister stated a number of principles about which he felt there was general agreement, one of which was that the causes of crime were environmental conditions such as educational disadvantage, emotional disturbance and social inadequacy, and that the environment of an institution was basically unsuitable for encouraging individuals to become responsible members of society. Now, the judiciary was also in on the Act during these years. In 1969, Judge Butler introduced a new form of sentence into the limited panoply of options for the Irish judiciary in the case of the State Woods and Attorney General. This type of sentence became known as the Butler Order and involved the imposition of a custodial sentence with the direction that the offender should be brought before the court again after having served a specified portion of the sentence. At that point, the judge would then make an assessment of whether the remainder of the sentence should be suspended, subject to the accused entering a recognizance involving undertakings to keep the peace and typically to participate in certain activities or seek help for an addiction, for example. In this case, the judiciary took it upon themselves to create a rehabilitative alternative to the prevailing sentencing options. Suggestions for further sentencing reform came from the bench in 1972. Mr Justice Henchy, while sentencing a repeat offender in the Central Criminal Court, stated that he regretted the fact he had no power to arrange a more suitable form of treatment. Specifically, it was suggested that instead of judges having the sole power to remand a person to a mental hospital or psychiatric institution for treatment, and these are his words, independent lay assessors should be employed in courts and proper professional diagnostic services be made available before any attempt is made to deal with offenders. All of this tends to support the conclusion by Shane Kilcommons and others that as belief in rehabilitation waned elsewhere, it began to be formally embraced in a modest way by the Department of Justice, and I would argue beyond. Now, as many of you will know, the 1970s was also a time of great crisis within the prison system. The Troubles placed a great deal of strain on a prison system which was beginning to become overcrowded and affected by drug addiction. The Department of Justice became a secretive and defensive place, and there was a huge degree of emphasis placed on security and defence of the state. However, in the midst of this, the Department of Justice did continue to pursue a rehabilitationist agenda, and successive ministers for justice declared their commitment to the principles of rehabilitation, such as Minister Jerry Collins in 1978. Moving on to the 80s, well, I always sigh whenever I talk about 1980s prison policy. But in those years, rehabilitation was viewed almost as a luxury penal policymakers couldn't afford in those years of very severe overcrowding, doubling up high levels of temporary release and very limited funds for the prison system. Rehabilitation is a word little enough used by policymakers during the 80s. But it was a significant feature in the reports carried out on the prison system during these years. The Whittaker Committee in 1985 stated that rehabilitation should be the aim of the prison system, and the McBride Commission and the Council for Social Welfare were highly critical of what they saw as a lack of rehabilitative efforts within Irish prisons. The lack of any effective response by the governments of the 1980s to these reports is telling. For them, rehabilitation had little place in a system under such immense strain. What is important, however, is the lack of active opposition to rehabilitation as a concept. Indeed, when the prison system and perhaps its policymakers recovered from the crisis-ridden 1980s, the 1994 Department of Justice document, The Management of Offenders, a 5-year plan, sought to introduce a positive sentence management committee for each prison. And it's interesting to reflect here on the perhaps subtle change of language away from rehabilitation to this contemporary concept of positive sentence management. Now, much less in the way of hesitation or holding back regarding criticism of the concept of rehabilitation was evident in the mid-1990s. Governments of that period did not speak of, never mind laud, rehabilitation. Opposition parties tended to link the concept of rehabilitation to a general softness on crime. And Liz O'Donnell had this to say in 1994, "My generation grew up with a liberal approach to crime. However, as one encounters crime, those liberal views are quickly diminished." She also criticised a lack of prison building as being an example of a woolly-minded preoccupation that all criminals are ultimately victims in 1997. A Fianna Fáil TD criticised temporary release, saying that the prison system had a higher turnover than Dunn Stores. John O'Donoghue is famous or infamous for his statements on the prison system from this time, but Ivor Callally in 1997 asked a series of questions of the Minister for Justice regarding the provision of facilities and items such as magazines to prisoners. He then criticised the government for providing swimming lessons, outdoor pursuits and telephone calls to prisoners. Now, there are a great many things which could be said about the 1990s, which I do not have time to go into here, but perhaps the greatest contrast with the 1960s, and I argue its most pernicious legacy, is the following. In the 1960s, the debate about prison policy concerned what prisons should do, what it should be for, the objectives of punishment and the objectives of prison. In the 1990s, the debates revolved around a single, ultimately extremely narrow and sterile issue: prison space and prison building. What prisons should do, apart from lock more people up, was not on any political agenda. But there is complexity here, as it was also in this decade that treatment programs for those convicted of sexual offences were established. And in the 2000s, there are statements from Michael McDowell to the effect that he was interested in developing new prison facilities to improve conditions. And he was the minister who oversaw reform of the temporary release system, but crucially not its abandonment. Temporary release was restated as being of importance to reintegration and to sentence planning. However, rehabilitation clearly had lost the cachet that it had had in the 1960s and the 1970s. That is certainly clear. Perhaps rehabilitation came in those years something of a dirty word. So what of today? Well, as somebody is reputed to have said in the 1960s, when asked to comment on the effect of the French Revolution, it's too early to say. We have the language of rehabilitation reappearing in official discourse. And I give you an example from the terms of reference of the Thornton Hall Review Group. And you'll see in the fourth line the reference to rehabilitation reappearing there. And also, interestingly, an interest in alternatives to custody. So is rehabilitation back, perhaps? I'm not sure, but I don't think it would be controversial to argue that it remains more of a concept than a practice in Irish prison policy. So what does all of this tell us about rehabilitation in Ireland and more generally about the concept itself? Well, first of all, the term is used by people in different ways, and it's not always clear what people mean when they're using the term, and arguably much of its usage is derived from a political agenda or philosophical position on what punishment should be for. The term can be positive or negative depending on what else is going on in penal policy. If you feel that you're tough on prison, you tend not to talk about rehabilitation, or you tend to talk about it in disparaging ways. If you're interested in reform and so on, you tend to get more mention of it. That goes without saying. What is interesting, however, is that as an objective of punishment, penal welfarism and rehabilitationism were present in Ireland to some degree in the 1960s and the 1970s. So why is that? Well, if we think back, if we go back to Garland's work from 1985, we find that he details a number of conditions which he describes as being necessary for the creation of penal welfarism. And these were present in Ireland to a certain degree during these years. The 1960s has been described as a decade of progress, of modernisation, involving a shift to the left in politics and increasing prosperity. And the experience of Ireland indicates that those background conditions, an affluent financial context, the support of social elites, and a style of governance, I suppose, which emphasises social solidarity, as well as the absence of an effective opposition to the concept of rehabilitation, are essential conditions for the creation of its practices. But I think what Ireland also shows, and what Garland's account doesn't really contain, is the importance of individuals. I'm not certain Charles Haughey had a fully developed understanding of rehabilitation and what its role in the Irish criminal justice system was, but I do believe the fact that it was associated with being European, modern, exciting, forward-thinking was highly influential upon him. And I think these things matter, and they deserve our attention. And I love this image from the 60s. It's Sean Lemass, the Taoiseach, associated with a huge amount of this change and development and modernisation of Ireland. And you've got your stereotypical leprechaun in the corner, but if you look closely, he's pulling back a curtain revealing Ireland's increasing modernisation. So I think the combination of those background conditions, of the favourable prospects for rehabilitation occasioned by the developments of the 1960s, along with the specific involvement of ministers and civil servants, was really essential. So in sum, I think rehabilitation needs both those conditions and supportive, influential individuals. I want to move on then to look at the second part of my talk, which isn't as long as the first, you'll be glad to hear, which relates to barriers to research into prison policy. Now, underpinning the Rehabilitationist project was a criminological research base, or at least an interest in research. And it's also true to say that research showing that rehabilitative programs were sometimes ineffective has also been part of its downfall. But I'd like to examine the barriers to research on prison policy and prisons in Ireland at present. And this part of my lecture will be much more practical and suggestive of reform, as there are many people here who are in a position to do something about these issues. There is a much bigger issue which Ian O'Donnell has written about regarding whether research can actually produce outcomes which penal reformers might consider not to be progressive. It is true that if we conduct research and find failure, we open up the possibility of alternative, more repressive policies. What I want to focus on, however, is some basic elements of the research landscape that Ireland lacks. Our criminal justice data in Ireland is generally of poor quality. We lack basic statistical information and have a poor statistical infrastructure. To give you some examples, we lack full information on the sentence length and offence type in the annual reports of the prison service. We lack full demographic information on who our prisoners are. We are unable to link data across the criminal justice system, though I understand this is changing and this is very welcome. We are also unable to link data outside the criminal justice system to our data repositories in health and education and so on, to give us a full picture of what our current prison population is like, proper, robust statistical evidence of its needs. We know very well that we will find a picture of multiple disadvantage for many, but without the ability to capture this information repeatedly, our capacity to argue about the need to see criminal justice as just one aspect of social policy is sorely diminished. More basically, we need to make the prisoner record information system available publicly on an anonymous basis and with appropriate ethical safeguards. And I think this would stimulate much more quantitative research amongst scholars of penal policy. I'd like to say a couple of words about ISIS. Some of you may be familiar with it. It's the Irish Sentencing Information System. And as some of you will know, it's available on irishsentencing.ie. And it's a very valuable development in increasing our understanding of sentencing and the factors which judges take into account. The database contains information on the sentence received for those cases which have been captured by the database, and some basic information on the person sentenced. But the information is not always recorded consistently, not all information is present, and the information is not presented in a way that makes it easy for the sentencing researcher to work on. In addition to this, there's no information given on whether the sample sizes for particular offences can allow for meaningful statistical analysis, for example. So there's much work to be done here, and I would very much like to see what is an excellent start with irishsentencing.ie be developed further, and with very clear input and close working with the Central Statistics Office. I think, however, there are also deficits of imagination. It strikes me almost every time there is a debate about prison policy, we encounter a blind spot. We're very experienced in talking about prison solutions to criminal justice problems, or criminal justice solutions to prison problems, but we lack the insight and the tools to understand prison policy as one facet of a much larger question of social policy. What is the role of prison in improving society? How is prison part of broader social policy problems? This is a much bigger issue, but very basically we lack the ability to link data from the criminal justice system to other sectors. Imagine what would be possible with data linked in an aggregated and anonymous way across health and education, for example. In Western Australia, where they have the ability to link criminal justice data to health and education and social policy repositories, a study has been undertaken to link the records of those in prison with health records in order to investigate the morbidity and mortality of the prison population. A large project has also been undertaken to link the records of young people in conflict with the law and health, education, child protection and disability data to examine developmental outcomes for children. Here we have a blank canvas. As for lawyers, well, as somebody who is involved in the training of law students, I think those of us who are involved in legal education are seriously in default when it comes to providing them with a rounded and socially useful training. And we are also depriving our policy formation process of the talents of very many bright people with useful things to say about criminal justice. Lawyers are generally not trained in statistics, nor in research methods outside legal ones, and I consider this to be a major inhibitor to research and change, and I think is generally an extremely old-fashioned way of doing things. Now, the third and final part of my talk will examine aspects of the experience of penal reform movements in Ireland. If you like to get things done, then penal reform movements are one way of doing that. Now, in Ireland, there are very few reform movements to speak of. Historically, any penal reform organisations have been linked with the Republican movement, and particularly the Civil War period, the emergency, and the 1970s. Our lack of a civil society tradition in this area generally is very interesting. Now, there are honourable exceptions, of course, such as the organisation that we're here to support this evening, and of course the Irish Penal Reform Trust. But a very different and most interesting group from the Civil War and emergency period is the Women's Prisoners Defence League, also known colloquially as the Mothers. This group was established by Maud Gonne McBride, there she is, a former prisoner herself, the mother of Sean McBride, of course, amongst other things. And incidentally, later in life, she set up a jam-making factory in Roebuck House to try and provide employment for prisoners on release, so a practical one. The League also involved Charlotte Despard, who was later active in the Workers' Party, Helena Maloney, Dr. Kathleen Lynn, and Dorothy McCardle. Now, their activities revolved around protest. And here are some of the League's members, for example, engaged in a hunger strike outside a prison. What they liked to do was make speeches, visit prisoners, agitate, give speeches on O'Connell Street, for example, paint slogans on walls and things. And in terms of their impact, well, it seems that on government policy, their only impact was to create frustration amongst members of the government. And we've two quotes here from two TDs from the 20s. The first one, Alec McCabe, TD, saying, "Why not let out these prisoners and put an end to the campaign of these wild women who spend their Sundays and the time they should spend in their homes orating from the ruins in O'Connell Street." And Kevin O'Higgins, TD, described them as hysterical young women who ought to be playing five-fingered exercises or helping their mother with the brasses. Now, in assessing their impact, we must remember that the state in these periods considered itself under attack, and the prison system was part of its defensive strategy. Their association with Republicans meant that they were not acceptable to policymakers, to use Mick Ryan's term. But to say that or to critique them on that basis misses the point of them. They weren't interested in cooperating, they were a protest movement. But if you do want to influence government, if you want to define your success in those terms, my own experience and the literature tells us some quite interesting things. Governments don't always listen to or use evidence, but reform organisations can't do without it. It's essential for their credibility. Ready-made solutions are extremely attractive. There are dangers here in denying the complexity of issues, which Alex Stevens in a 2011 article writes about. But, dare I say, busy politicians sometimes like others to do the thinking for them, so you can have influence if you're able to do that. Staying critical and not becoming part of the Whitehall dining clubs that, again, Mick Ryan writes about so forcefully is crucial. And recognising the power of individuals and the importance of personality and capitalising on that is essential. The history of Irish prison policy tells us that individuals have massive influence over the future direction of the penal system for many years into the future, for good or ill. If you want to have influence, you need to talk to them. So finally, to sum up, my lecture has attempted to sketch the history of rehabilitation in Irish penal thinking, to draw attention to some barriers to research and suggest ways to reduce them. And I've also provided a brief examination of reform movements in Ireland and one or two practical ideas about how to influence change. From what I know and have read about Martin Tansey, I know he was an advocate of penal policy based on a rehabilitative ethos, was a man committed to research-led policy and someone who desired reform and, crucially, worked hard to achieve it. For that, I think we should thank him by trying to pursue those actions in our times, and I thank you for listening. Thanks very much.
Once you've left your stuff questions. We have a slide that I was going to pop up there. We have a tradition in this organisation of actually respecting the fact that some of us, particularly those working in government, don't always get the opportunity to speak freely vis-à-vis their own views. And that was one of the key things that Martin and the founders were concerned with, and that we retained in the organisation. So as a result, we are going to invoke Chatham House rules at this stage. We're going to turn off the camera so that those of you who wish to ask questions out of school, maybe, or whatever, have the freedom to do so here, and that nobody can report on them outside of this venue. Okay? So I'm going to invite my Vice Chair, Finbar here, to come up here, please, and to chair the Q&A session, and I'm going to turn off the camera. Okay, so put your hand up if you've got a question, please. Are we all shy?